Hi, I'm Jason Sullivan of Rathbone Group, and this is On Subrogation. This video is going to focus on a scenario where you may think your insured has double recovered, but in actuality, there's no double recovery. We're going to look at punitive damages and how they work in South Carolina. The first question is, what are punitive damages? And these are damages awarded by the court not to compensate somebody for their loss or their injury, but rather to punish, make an example of the person who caused the harm. A common example would be if somebody is driving while intoxicated, they're driving drunk and they cause an accident, the court wants to make an example and they want to punish the person that put the public in harm's way by their reckless actions. And so they may award punitive damages. In South Carolina, punitive damages are generally limited to either 3 times the compensatory amount that's awarded or $500,000, whichever is less. There are some examples or exceptions to this rule where if somebody intentionally causes harm, that cap or limit on punitive damages is removed. So how does this come up for you as a subrogation professional? Let's say you have an insured and they're rear-ended by a drunk driver. Your company pays the $15,000 to repair your insured's vehicle, and now you have a subrogation claim for $15,000. Your insured also has injuries, and they hire a lawyer and they pursue those injuries. And they either get a settlement or a judgment in which they allocate $20,000 to medical bills and expenses. Those are the compensatory damages. They get another $40,000 for pain and suffering. And because they had the 20 in compensatory damages, the court, or there's a stipulation that there are punitive damages of another $60,000. So you have $20,000 in compensatory, another $40,000 for pain and suffering, and then another $60,000 in punitive damages. If you go knocking on the door of the at-fault carrier and say, hey, here's our $15,000 property damage subrogation claim, you need to pay us the money back, you may hear that that other carrier has already exhausted their PD limits. And the reason for this is, in South Carolina, a liability carrier can use their PD policy limits to pay punitive damages. So your insured may get the full $25,000 if they have, the at-fault party has a $25,000 BI liability policy, and that carrier could use $25,000 of the PD liability policy to pay towards that $60,000 punitive damage award. So all the limits have now been exhausted. And when you hear your insured was paid that $25,000 PD liability, you may say to yourself, well, wait a minute, we paid the liability, they've double recovered. But because that $25,000 PD liability was paid towards punitive damages, there's actually no double recovery. It's something to be on the lookout for when you make a claim on another carrier and they say they've already paid their PD limits and you're unaware that your insured had any out-of-pockets. It may be because there was some kind of stipulation or judgment that awarded punitive damages and the other carrier used their PD limits, which is approved, to pay that punitive damage award. If you have any other questions on subrogation topics or your right of recovery, feel free to contact us at video@rathbonegroup.com. I'm Jason Sullivan, and that's the long and short of it.